We are anonymous. We are not a political party, not a corporation, not a government agency. We are a decentralized collective of activists, researchers, technologists, and citizens who believe that power must answer to the public. When institutions protect the powerful instead of the vulnerable, when secrecy replaces transparency, and when political influence appears to bend the justice system, we pay attention, we document, we analyze, and we speak. Today we are exposing what appears to be a hidden strategy linking Ghislaine Maxwell and Donald Trump, a strategy built on delay, document suppression, legal maneuvering, and political timing. Let's walk through this carefully because complexity is often used as camouflage. Ghislaine Maxwell has filed a motion in the 2015 defamation case brought against her by the late Virginia Giuffre. In that motion, Maxwell is asking a federal judge, the same judge who previously presided over that civil case, to block the release of approximately 90,000 documents that have not yet been produced under the Epstein Transparency Act. These documents reportedly include depositions Maxwell gave in the Giuffre case, along with extensive discovery materials, 90,000 documents, sworn testimony, emails, communications, potentially explosive information. Despite a federal law designed to bring transparency to Epstein-related materials, those documents remain concealed. When we examine Maxwell's recent legal filings, a pattern emerges. It does not look like random legal scrambling. It looks coordinated. It looks strategic. Maxwell was previously held in Tallahassee and later transferred to the federal prison camp in Camp Bryan, Texas, a minimum security facility often described as far more comfortable than typical federal prisons. This transfer occurred during a period when Todd Blanche, Donald Trump's former criminal defense attorney, had become the #2 official at the Department of Justice. That connection matters. Todd Blanche represented Trump in high-profile criminal matters. He now occupies a powerful position within the DOJ. At the same time, Maxwell's legal positioning and prison conditions shifted in ways that raised serious questions. When Maxwell was recently deposed by the House Oversight Committee, she was represented by David Oscar Marcus, a prominent and expensive Florida defense attorney known for representing high-profile clients. Marcus is reportedly close to Todd Blanche. At the beginning of that deposition, Marcus announced that Maxwell would invoke her Fifth Amendment right against self-incrimination. He also publicly suggested that if Donald Trump were to grant Maxwell a pardon or commutation, she would be willing to say favorable things about him. That statement alone should have set off alarms. Now consider the contradictions in Maxwell's legal strategy. In the civil defamation case brought by Virginia Giuffre, Maxwell is represented by Laura Menninger and Jeffrey Pagliuca of Haddon, Morgan & Foreman PC, a major Colorado law firm known for high-level litigation and significant hourly rates. These are seasoned elite attorneys. Yet, in a separate federal proceeding, her habeas corpus petition, Maxwell claims she cannot afford a lawyer. She presents herself as proceeding pro se, essentially arguing that she lacks the resources to retain counsel and needs additional time because she cannot adequately prepare her filings. If she can afford top-tier lawyers to fight the release of 90,000 documents in a civil case, why can she not afford counsel for a habeas petition that directly affects her freedom? The answer may not be about money. It may be about delay. Maxwell has already exhausted her direct appeals. She was convicted in the Southern District of New York on charges related to child sex trafficking and sentenced to 20 years in prison. She appealed to the Second Circuit Court of Appeals. The appeal was rejected. She then petitioned the United States Supreme Court. That petition was denied. Her direct appellate path is closed. Now she is pursuing a habeas petition under Section 2255, arguing unlawful detention based on newly disclosed evidence, specifically millions of documents released under the Epstein Transparency Act. In a letter dated February 17, 2026, Maxwell asked Judge Angel Mayer in the Southern District of New York for additional time to amend her petition. She claims she has no internet access in prison and cannot properly review the 5.4 million documents that were disclosed. She argued that these materials revealed that some complainants were not minors at the time of the alleged abuse, that ages were misrepresented, and that certain photographs introduced at trial did not accurately reflect time, place, or age. She claimed that prosecutors knew this and still presented the evidence. She also renewed arguments about the 2007 non-prosecution agreement reached with Jeffrey Epstein, asserting that its co-conspirator clause should have protected her from indictment in the Southern District of New York. These arguments have largely been litigated before. Yet they reappear now, reframed under the claim of newly released materials. Why now? Because timing is everything. Judge Mayer granted her additional time. Her amended filing deadline extends into mid-2026. Any ruling could stretch into 2027, deep into Donald Trump's presidential term. Delay creates leverage. As long as her habeas petition is pending, Maxwell can continue invoking the Fifth Amendment in other proceedings, arguing that further testimony could affect her legal position. That invocation shields her from answering certain questions in congressional or civil contexts. Legally, after conviction and exhaustion of appeals, the Fifth Amendment protection narrows significantly regarding the same conduct. But procedural posture can create ambiguity, and ambiguity buys time. Now return to the 90,000 documents Maxwell is fighting to conceal. These materials stem from the Giuffre versus Maxwell civil case. Maxwell argues that documents from that case were obtained by prosecutors through a grand jury subpoena and therefore fall under Rule 6E of the Federal Rules of Criminal Procedure, which governs grand jury secrecy. She contends that because those documents entered the criminal process, they must remain confidential. However, the Epstein Transparency Act was intended to override many of these barriers and allow public access to Epstein-related records. Courts previously resisted releasing certain grand jury materials, but the act clarified Congress's intent transparency. So the question becomes unavoidable: what is in those 90,000 documents? We know from prior reporting that materials in Maxwell's criminal case included allegations involving Donald Trump. Some documents reference serious accusations, including claims by a survivor who alleged sexual assault involving Trump. Other allegations described Epstein introducing a young woman to Trump and asking what he thought of her. Trump has denied wrongdoing and has sought to distance himself from Epstein, despite documented social ties and public photographs over the years. Were questions about Trump asked during Maxwell's depositions in the civil case? Were there emails, financial communications, or sworn statements touching on their interactions? Did Maxwell testify under oath about Trump's knowledge, conduct, or connections within Epstein's network? We do not know. And that is precisely the problem. 90,000 documents is not a small collection. It suggests extensive testimony and evidence. If there is nothing damaging within them, transparency would settle the matter. If there is damaging information, concealment benefits those implicated. Now consider the political context. Donald Trump has a history of granting clemency to allies and individuals connected to his political orbit. During his previous term, he issued pardons and commutations to controversial figures with personal or political ties to him. The idea that clemency could be used as leverage is not without precedent. When Maxwell's lawyer publicly floated the idea of a pardon in exchange for favorable statements, that was not ordinary courtroom language. That was political messaging. Todd Blanche's presence inside the Department of Justice leadership creates a channel of influence that cannot be ignored. Even if no explicit agreement exists, the alignment of incentives is obvious. Maxwell benefits from delay and potential clemency. Trump benefits from suppression of potentially damaging documents and from preventing damaging testimony. DOJ leadership aligned with Trump benefits from minimizing political fallout. This does not require a signed conspiracy. It requires shared interests. Maxwell's strategy accomplishes multiple goals simultaneously. It delays resolution of her habeas petition. It provides justification to continue invoking the Fifth Amendment. It aggressively seeks to block release of 90,000 documents. It reframes the narrative toward alleged evidentiary disputes rather than the underlying crimes, and it runs out the clock. Every month that passes reduces public urgency. Media cycles shift. Political calculations evolve. Attention fades. The Epstein scandal shook public trust not only because of the crimes alleged, but because of the network of wealth, power, and influence surrounding them. Financiers, politicians, celebrities, and international figures appeared within Epstein's orbit. When Epstein died in federal custody under highly controversial circumstances before trial, many Americans concluded that powerful people would never be fully exposed. Maxwell became the face of accountability, but accountability without full transparency is incomplete. The Epstein Transparency Act was meant to lift the veil, yet we are still fighting over tens of thousands of documents. Maxwell claims she lacks access to computers in prison while residing in a minimum security facility known for comparatively relaxed conditions. At the same time, she retains elite legal teams in other matters. The narrative shifts depending on the courtroom. Donald Trump frequently positions himself as an outsider battling entrenched corruption, Yet when it comes to Epstein-related disclosures, transparency appears inconvenient. If the documents contain nothing of consequence to him, full release would clear the air. If they do contain damaging information, delay serves a clear purpose. We see patterns. We see timing. We see incentives. We see a convicted trafficker invoking poverty in one case while deploying high-powered attorneys in another. We see aggressive efforts to block document disclosure. We see procedural extensions that conveniently push decisions into politically advantageous timelines. We see clemency floated publicly as a bargaining chip. The American public deserves the full record. Survivors deserve to know that the system does not protect the powerful at their expense. The justice system's credibility depends on equal application of the law, not selective transparency. If there is nothing to hide, release the 90,000 documents. If Maxwell's habeas petition lacks merit, resolve it swiftly. If there is no coordination demonstrated through independent oversight and full disclosure, secrecy fuels suspicion. Transparency restores trust. We are anonymous. We are legion. And we are watching.